Welcome to your first day at PIF Collections. I'm Karen, the agency's compliance officer. Go ahead and sign in and I'll show you around. Here at PIF, we collect many types of consumer debt, including healthcare accounts. This means you'll be handling certain health information that's protected by the Health Insurance Portability and Accountability Act of 1996, or HIPAA. It's important for you to be aware of HIPAA rules and regulations because violating HIPAA can result in some serious consequences, like losing your job, personal fines, or in some cases, facing criminal prosecution. As your compliance officer, it's my job to make sure you're prepared before you hit the phones. We're going to start in the training room to go over some HIPAA basics. Then when you're ready, you'll head out to the collection floor to put your knowledge to the test. Click the icon above to enter the training room. Take a moment to review the learning objectives, then click the next arrow. What is the Health Insurance Portability and Accountability Act? Click on the numbered timeline to learn more. Before HIPAA. Before HIPAA, there wasn't a national set of standards protecting individuals' healthcare records. There was a concern that patients' medical information wasn't being kept confidential, and this could harm people. For example, if an employer could somehow find out about a person's medical condition, they might use it against them, and this could be discriminatory. As patients, HIPAA helps keep our healthcare information confidential, so we don't have to worry about harmful consequences of getting some kind of medical care when we need it. HIPAA introduced. The HIPAA Insurance Portability and Accountability Act of 1996 increased the privacy and security of people's information, helped establish national standards for electronic healthcare transactions, including filing claims with insurance companies, and gave individuals the ability to continue or transfer their health insurance when they leave or change jobs. HITECH Act created. In 2009, the HITECH Act, the Health Information for Economical and Clinical Health Act, was created to help promote the use of electronic health record technology. HITECH expanded existing HIPAA privacy and security standards by increasing the enforcement of HIPAA rules to companies that provide services to the healthcare industry, and by raising the penalties for non-compliance. HIPAA today. Because of the privacy and security requirements the law imposes on healthcare providers and the companies that provide services for the healthcare industry, compliance with HIPAA requirements as amended by the HITECH Act has become very important for debt collectors engaged in the collection of healthcare debts today. Basic HIPAA rules. Although HIPAA law as a whole is quite substantial, you need to be familiar with portions of these key components. Click on the sections to find out more about each rule. The Privacy Rule. The HIPAA Privacy Rule establishes the standards for protecting individuals' health information and medical records. It sets limits and conditions on the uses and disclosures of protected health information, PHI, and gives individuals certain rights over their health information, including rights to examine and obtain a copy of their health records and to request corrections. The Security Rule. Most patient data is stored and transferred electronically. The HIPAA Security Rule establishes security standards for protecting PHI that is maintained or transferred in electronic form. This is referred to as ePHI. The Security Rule requires companies to implement and maintain administrative, technical, and physical safeguards for protecting ePHI. The Breach Notification Rule. The Breach Notification Rule sets the requirements for how an entity should provide notification in the event of a breach of unsecured PHI. A breach means the acquisition, access, use, or disclosure of PHI in a way that has compromised the security or privacy of that information. Who must comply with HIPAA? Those who are responsible for complying with HIPAA fall into one of these two categories. Covered entities. A covered entity, or CE, is a health plan, healthcare clearinghouse, or healthcare provider who creates, stores, or transmits an individual's personally identifiable health information. The clients your company recovers medical debt for are considered covered entities. Examples of CEs include doctors, dentists, hospitals, nursing homes, pharmacies, health insurance companies, and government programs such as Medicaid or military healthcare plans. Some responsibilities CEs have under HIPAA include safeguarding PHI when it's being stored or transmitted, providing a privacy notice to individuals explaining how their PHI can be used or disclosed, allowing individuals specific rights to their PHI, maintaining company HIPAA privacy and security policies and procedures, to have written agreements with their business associates that explain how PHI will be used, disclosed, and stored, and audit the BA to be sure they follow it. Business associates. Business associates, or BAs, are the individuals or companies who provide services for covered entities in which they are given access to PHI from the entity. Some examples include attorneys, accountants, administrative services, and billing companies. A collection agency collecting debts on behalf of a CE is considered a business associate. Likewise, any subcontractor used by the collection agency that has access to protected health information is also considered a business associate. Collection agencies who are considered BAs are directly responsible for many of the provisions under HIPAA, including staying compliant with certain HIPAA privacy and security rule requirements, being subject to periodic compliance audits, being subject to certain consequences and penalties for non-compliance, entering into and following the policies and procedures outlined in a business associate agreement. Business associate agreement. Before a covered entity is allowed to share protected health information, or PHI, with a business associate, HIPAA requires that the CE and BA enter into a business associate agreement. BA agreements are contracts that help clarify and limit the ways a covered entity will allow their business associates to use and disclose the PHI they receive from them. These agreements vary and are tailored to the specific needs of the CE. Different medical clients may place different restrictions on how they want you to use the PHI they provide. Make sure you're aware of the policies and procedures outlined in the BA agreements your company has with its clients. A BA is also required to have BA agreements with any of its subcontractors that handle or have access to PHI, such as an IT service provider or paper shredding service. Some companies may even have confidentiality agreements with vendors who frequent the building, such as a cleaning crew or delivery service. A BA agreement may address factors such as establishing that the BA will only use or disclose PHI in ways that are permitted by the contract or required by law, requiring the BA to implement appropriate safeguards to prevent unauthorized use or disclosure of PHI, requiring the BA to report to the CE any misuse or unauthorized disclosure of PHI. Protected health information. What is protected health information? The information HIPAA sets out to safeguard is referred to as Protected Health Information, or PHI. Click the PHI buttons below to find out more about PHI. PHI is the health information created, stored, or transmitted by CEs and BAs that has the potential to be used to identify the individual to whom it belongs. PHI is anything in a patient's healthcare file. PHI can be in any format, including electronic, paper, or verbal communication, and includes items such as demographic data, payment information, and details relating to a person's health. The PHI you see may include consumer's name and address, date of birth, social security number, payment history, account number, healthcare provider's name and address, name of the person's health plan, insurance, and certain details about procedures, doctors, or treatment. PHI and HIPAA rights after death. It's important to note that a person's health information is still protected by HIPAA for 50 years after the individual has passed away. There are provisions that allow the disclosure of PHI to a family member or personal representative involved in the consumer's medical care or payment activities prior to the consumer's passing, unless doing so against the wishes of the consumer before he or she passed. Please follow your agency's policies and procedures have in place for working on this type of account. PHI and HIPAA privacy and security rules. Before HIPAA, there weren't strict policies on the way a person's medical information could be handled, stored, or shared. HIPAA's privacy rule and security rule define regulations for uses, disclosures, and safeguard methods of PHI. These rules establish the guidelines for keeping sensitive information private and secure. Click on the icons to find out more about the rules. HIPAA Privacy Rule. HIPAA's privacy rule limits the way PHI can be used or disclosed. It states that PHI should only be used for the purpose of TPO, treatment, payment, or operations of the facility. The privacy rule outlines certain procedures and safeguards geared toward protecting PHI, including implementing company privacy policies, requiring HIPAA privacy training for employees, and limiting the use of PHI to what is called the minimum necessary. PHI and the privacy rule. The minimum necessary rule. One of the key components of the privacy rule is the condition that CEs and BAs only use, disclose, or request the minimum amount of PHI they need to achieve TPO, treatment, payment, or operations. This is called the minimum necessary standard. This means a collection agency's healthcare clients should only disclose PHI that is essential for collecting debts. This includes, but is not limited to, information such as the person's name and address, payment history, or name of the healthcare provider. In turn, collectors must limit their disclosures to the minimum necessary to collect on the debt. It's difficult to clearly define what the minimum necessary will be for every situation or circumstance. You should always make sure you are aware of any BA agreements that include minimum necessary stipulations. You should also check to see if your agency has policies or procedures regarding PHI and the minimum necessary. When working on an account, only use the PHI you need to get the job done. Individual rights to PHI. HIPAA's privacy rule works to give people more control over how their PHI can be used. These rights allow individuals to access and obtain copies of their health records, request corrections or amendments to health information they believe to be incorrect, know which entities have access to their PHI, receive privacy notices that outlines how their PHI may be used, approve or deny permission to use their PHI for certain purposes. Generally speaking, individuals who have the right to make their own healthcare decisions also have certain rights over their PHI. But there are individuals who may not be able to make their own healthcare decisions, or they've chosen to give that authority to another person. In these cases, a personal representative holds the rights. There are two types of personal representatives. The first is a legally authorized personal representative, such as a court-appointed guardian or the individual's power of attorney. The second type is a parent acting on behalf of a minor child. You should be able to disclose PHI to a personal representative as long as that disclosure follows HIPAA's minimum necessary rule, state law, and your BA agreement. Third-party communications. HIPAA doesn't expressly prohibit you from disclosing PHI to a third party. However, there are some factors you need to consider before disclosing PHI to anyone other than the consumer. Does the communication violate the FDCPA? Does the BA agreement prohibit this type of communication? Does the communication violate state law or company policy? Has the consumer requested restrictions on the disclosure of their PHI to a third party? Is it absolutely necessary to disclose information to the third party in order to obtain payment? Are you only sharing the minimum necessary to achieve TPO? The HIPAA security rule. Most patient data is stored and transferred electronically. HIPAA's security rule establishes the security standards for protecting electronic PHI, or ePHI. It's important that the integrity of ePHI remains secure at all times, while also staying accessible to authorized persons. The safeguards for protecting ePHI fall under three categories: administrative, physical, and technical. PHI and the HIPAA security rule. Administrative safeguards. Administrative safeguards refer to the administrative actions and policies and procedures that are in place to manage the development, implementation, and maintenance of ePHI security measures. Examples of administrative safeguards include designating a security officer to oversee the company's security policies and procedures, security awareness training for employees, having penalties in place for employees who violate company policies and procedures regarding ePHI, conducting periodic evaluations of the company's security policies and procedures, a record of all documentation signed by employees, HIPAA contracts. Physical safeguards. Physical safeguards are the physical measures, policies, and procedures meant to protect electronic information systems, such as computers storing ePHI, and related buildings and equipment from unauthorized intrusion or natural and environmental hazards. Examples of physical safeguards include limiting physical access to electronic information systems and ensuring that only properly authorized access is allowed. Policies that govern the transfer, removal, reuse, and disposal of electronic media and devices. Implementing policies and procedures that specify the proper use of and access to workstations where ePHI is accessible, such as your desk. Privacy screens where others can see information. Shredding documents containing PHI, including notes written by hand. Automatic screensavers on computers. Locked cabinets that contain PHI. Policies on the use of cell phones on the collection floor or where PHI is visible. Technical safeguards. Technical safeguards refer to the technology and the policies and procedures for its use that protect and control access to ePHI. Examples of technical safeguards include access controls, such as a unique login name or number to allow ePHI access to only authorized people or software programs. Automatic log-off for a computer after a specified time of inactivity. Implementing audit controls that record and examine activity in information systems containing ePHI. Implement safeguards that verify the identity or the person or entity attempting to access ePHI, such as requiring a password or PIN number. The encryption of ePHI that is being transmitted, such as through email. Violating HIPAA. Since HIPAA privacy rule compliance officially took effect in 2003, over 109,000 HIPAA complaints have been filed with the Office for Civil Rights, and more than 1,190 compliance reviews have been conducted. Click the buttons below to find out more about HIPAA violations. How do violations occur? Most HIPAA violations occur when the privacy or security of PHI is compromised, and there is a breach of the unsecured PHI. Unsecured PHI is defined as PHI that is not rendered unusable, unreadable, or indecipherable to unauthorized persons through the use of a technology or methodology specified by the security of HHS. A breach means the PHI has been accessed, used, or disclosed in a way that violates HIPAA law. What are common violations? According According to the U.S. Department of Health and Human Services, the most common HIPAA violations include impermissible uses and disclosures of PHI, inadequate safeguards for protecting PHI, lack of access to an individual's PHI, insufficient administrative safeguards for ePHI, use or disclosure of more than the minimum necessary PHI. Penalties and consequences of violating HIPAA. Four-tiered penalty system. BAs are directly liable for compliance with certain HIPAA privacy and security rule requirements, and can also be held to the enforcement actions and consequences for noncompliance. HIPAA violations can lead to personal, civil, or criminal penalties against the individual who violated HIPAA. The HITECH Act imposed a four-tiered system of penalties for HIPAA violations. Each level increases in degree of severity. Click below to learn more about each tier. Click the buttons to find out more about each tier. First tier violation penalties. Violations that were unknown, and even by exercising reasonable due diligence, still would not have been known. Penalties range from $100,000 to $50,000 for each violation, maximum of $1,500,000 for identical violation in a calendar year. Second tier violation penalties. Violations due to reasonable cause and not to willful neglect. Penalties range from $1,000 to $50,000 for each violation, maximum of $1,500,000 for identical violation in a calendar year. Third tier violation penalties. Violations due to willful neglect but occurred within 30 days from knowledge of the violation. Penalties range from $10,000 to $50,000 for each violation, maximum of $1,500,000 for identical violation in a calendar year. Fourth tier violation penalties. Violations due to willful neglect that go uncorrected. Penalties are $50,000 for each violation, maximum of $1,500,000 for identical violation in a calendar year. The Breach Notification Rule. The Breach Notification Rule sets the requirements for CEs and BAs to provide notification following the breach of unsecured PHI. In the event a breach of unsecured PHI occurs by a business associate, the BA must notify the CE within a reasonable amount of time, and no later than 60 days after the discovery of the breach. The Breach Notification Rule. If a breach occurs, the BA should provide the CE with the identification of those affected by the breach, as well as any information the CE may need to include in a notification to the affected individuals. This information may consist of a brief description of what happened, including the date of the breach and the date of the breach discovery, if known. A description of the types of unsecured PHI that were involved in the breach, such as social security number, date of birth, home address, account number, or full name. Any steps individuals should take to protect themselves from potential harm resulting from the breach. Notifying the individual. Once a covered entity discovers there has been a breach of unsecured PHI, the CE is responsible for notifying each individual whose PHI is believed to have been accessed, acquired, used, or disclosed. The CE must also report all breaches to the HHS, Department Health and Human Services, and if the breach involves 500 or more individuals in the same jurisdiction, notify a prominent media outlet. Likewise, to the BA, the CE must provide notice without reasonable delay and no later than 60 days following the discovery of the breach. Breach examples. Possible breaches may include releasing information to an unauthorized party, storing ePHI on a device, such as a laptop or jump drive, that is not secure, improper disposal of documents containing protected information, discussing an account with friends or coworkers, not logging out of a computer system containing PHI, when a system containing ePHI is hacked, accessing a person's account for any purpose other than TPO, treatment, payment, or operations. HIPAA compliance at work. HIPAA violations occur when PHI is accessed, used, or disclosed in a way that breaks HIPAA law. As a collector, it's your job to keep the PHI you work with private and secure. In order to do so, it's important that you are aware of potential violations that can happen while working to resolve an account and within your workplace. Click each breach icon to learn about potential violations that can happen while resolving an account and within the workplace. Potential HIPAA violations while working on an account. Here are some potential ways HIPAA violations can occur while you're working to resolve an account. Misuse of PHI. PHI should only be accessed, used, or disclosed in order to perform payment operations on the healthcare account you're working to resolve. You should also only use, disclose, or request the minimum amount of PHI you need to carry out the intended purpose of collecting payment. Sharing information across accounts. In the past, computer systems would often combine and store accounts for the same person under their name or social security number. Now it's best to store healthcare and non-healthcare account information separately. This may even be a requirement in some BA agreements. All the information contained in a consumer's healthcare file, which includes their name, phone number, and address, is considered PHI and therefore should not be shared to collect a non-healthcare account. Accessing more than the minimum necessary. Example. While working to validate a debt, a consumer may ask you for more specific information than is available to you in their account. This could lead you to accessing more PHI than is considered the minimum necessary. You can always refer a consumer to their healthcare provider or insurance agency to give them additional information. Depending on your agency's BA agreement, you may be able to ask your CE client to send more information to the consumer directly. The debt validation process should be detailed in your company's BA agreement and your company's policies and procedures. Check your office policy before taking steps to validate a debt. Violating a consumer's right to PHI. HIPAA gives consumers certain rights regarding their PHI. This includes giving patients the right to request restrictions on uses and disclosures of PHI, the right to access their electronic PHI, and the right to request amendments to their PHI. A consumer should be granted access to their PHI if requested. If the consumer is requesting more information than is available to you, you may need to refer the person to their insurance or healthcare provider. A consumer can request that you do not disclose PHI to certain third parties, even if those parties are authorized under HIPAA and state law. In the case that a consumer is wanting changes or corrections to PHI, your agency may be required by the BA agreement to forward any such request to the CE. Check your office policy before sending or amending PHI when requested by the consumer. Improper disclosure of PHI. While working on an account, you need to be mindful of how and to whom you disclose PHI. Since demographic information such as the consumer's name, date of birth, and address are considered PHI, you should take extra precautions to ensure that you're disclosing this information in a way that does not violate HIPAA law or your BA agreement. Workstation violations. You have to be careful about the way PHI is stored and who may be able to see it. Be sure to take proper precautions to ensure that PHI is safe in your work area. Risk factors in your work area may include account information on your computer screen, printed documents containing sensitive information that may be sitting on your desk or in the trash, personal notes or written reminders. You can keep your area secure by making sure you're properly disposing of sensitive documents, not leaving account information up on your computer while away from your desk, being mindful of third parties, such as family members of employees who are in the office and may see account information on your screen or on your desk. Personal interactions. Everyone has the right to expect that their health information will be kept confidential. Part of ensuring people's privacy is to refrain from discussing their PHI with anyone but them or a responsible party. It can be tempting to talk with coworkers, friends, or family about your work or the conversations you have with consumers. However, collection agencies can only use PHI to perform payment operations. Therefore, discussing a consumer's private information when not performing payment activities would be a violation of HIPAA. If you need help or have questions about an account, you may be able to speak to a supervisor. Use discretion and always follow your company's procedures when discussing a healthcare account. Social media. When using social media such as Twitter, Facebook, blogs, or other sites, it is important that you use the same discretion in your posts as you would in your personal interactions. Even if you use privacy settings or you feel you're posting anonymously, it is still considered a public disclosure, and you could be in violation of HIPAA privacy laws. Are you ready for the final quiz? The final quiz consists of 20 questions. You must pass with an 80% or higher in order to receive your certificate of completion. Good luck!